This is continuous coverage.
Continuous coverage.
In the trial of Lori Vallow Daybell from the Hidden Killers podcast.
We're up to segment number 4 in our coverage of the trial of Lori Vallow Daybell. Let's head to the courtroom.
And the rules are you need to flip it over. So, okay, are you done refreshing recollection?
Yes.
Okay, that's all right. We just follow the rules.
I got you.
All right. What date did you go to search the Jeep in Rexburg, Idaho?
The Jeep was searched on November 18th, 2019.
Okay. And so when you and teams went up to Rexburg to search that Jeep on November 18th, at that time, what was law enforcement's interest in Tylee Ryan?
Tylee Ryan was, again, known to be using the Jeep, believed to be using the Jeep, so we were checking to see if she used it, also if Alex used it. But again, we hadn't seen or located her as of that date.
Okay. And in fact, did you ever see and locate her?
No.
Okay. And then after that, I believe you said November 26th was the date law enforcement reached out to Lori Vallow about JJ?
It was November 26th that the welfare check for the children by Rexburg Police Department was made. And then the call I received that night from Melanie relaying information that said otherwise. And then November 27th, which was Thanksgiving, Rexburg then completed a more intensive search of those properties where Alex, Lori, and Melanie Boudreau were living.
Okay. And so after that, what sort of steps did you and the Rexburg Police Department take in this investigation?
Again, primary focus on locating the kids now. I was tasked with writing search warrants for cellular data and location data for the involved parties.
Okay. When you say the involved parties, who are we talking about at this point?
At this point, I'm talking about Alex Cox, Lori Vallow, Tylee Ryan, and Melanie Boudreau.
Okay. Talking about Tylee Ryan, did you receive information about any cell phone data related to Tylee Ryan?
Yes.
What was that data?
The data showed her device was utilized both in Arizona and in areas of Idaho, and at the point of our investigation, it was now showing in the area of the Hawaiian Islands, Kauai.
Okay. And this was in December?
Yes, ma'am.
Okay. Did it ever show up anywhere else?
I believe it was in Missouri for a brief time.
Okay. And that was the cell phone of Tylee Ryan, correct?
That was the cellular device that was associated with her cell phone number and provider, yes.
And subsequent or sort of contemporaneous, because all these things are kind of happening at the same time, right?
Yes, ma'am.
Okay. Did you have information as to the relationship between Brandon Boudreau and Melanie Boudreau in terms of divorce or together?
They were legally married still, but they were nearing the end of their divorce at the time of Brandon's shooting.
Had there been any discussion of life insurance?
Brandon and Melanie had a life insurance policy that required each of them to sign in order to modify or null and void the life insurance policy. At my time in contact with Brandon, that policy was still valid, and if Brandon were to die, Melanie would get $200,000 or more.
And did you have any information about how much Melanie had received as a part of their divorce settlement from Brandon Boudreau?
Relevancy.
Motive, Your Honor?
Relevancy.
Sustained.
Your Honor, may I be heard?
I've made a ruling on that, Ms. Smith.
Okay. Was there, without the amount, was there a payout from Brandon Boudreau to Melanie Boudreau as a part of their divorce proceedings?
Yes, ma'am.
Okay. And did you have any evidence to suggest that cash had exchanged hands between any of these people of interest?
Objection, relevancy.
It's part of a conspiracy, Your Honor.
That all overrule.
Thank you. Did you have any evidence that cash had been exchanged between any of these parties involved?
I'm going to object unclear as to who these parties are.
Yeah, that was vague.
Okay, when we say the parties, the people you have identified looking for the cell phones for, Melanie Boudreau, Chad Daybell, Lori Vallow, Tylee Ryan. Did I miss anybody? Alex Cox.
Alex Cox.
Okay. These 5 parties, and as part of your investigation, monetary gain is often a motive for homicide, right?
That is correct.
Okay. So looking at cash amounts and cashes exchanged between people or how much money somebody stands to benefit for a homicide is an important factor for an investigator to look at, right?
Yes, ma'am.
Did you receive evidence that any of these 5 people had exchanged money or cash?
Yes.
What information did you have?
There were Venmo exchanges that were made, and there were also substantial amounts of money that were exchanged that were referenced in text messages with each other.
Okay. And while you were looking for Tylee Ryan, did you find any evidence that she'd ever enrolled in college?
No.
Did you find any evidence that Tylee Ryan ever drove that Jeep personally after September of 2019?
No.
One moment, please, Your Honor.
Yes.
Thank you. I appreciate it, Officer. That's all, Judge.
All right. Thank you, Ms. Smith. Any cross?
Your Honor, we know that the court has a prior ruling in February regarding the 404B evidence. We believe that all of the information garnered today in testimony was either 404B or so intertwined with 404B that we could not be able to effectively cross-examine him without losing our right to this 404B on appeal. So we're not going to have any questions.
Okay. I understand, Mr. Thomas, then, so there won't be any cross-examination. Then that would conclude the testimony of Officer Pollard. Can he be released from any subpoena?
We would ask that he is.
Any objection?
No, Your Honor.
Okay. That'll conclude your testimony. Thank you for appearing. The bailiffs will assist you out of the courtroom.
Thank you, Judge. Thank you, jury.
We would ask that you strike the last statement where he indicates thanking the jury. I think that's inappropriate.
All right. Let the witness be excused. I'll address that here in a moment. All right. In regards to that last comment, it's maybe something that happens in Arizona, not typical in Idaho, that a witness would address the jury. So to the extent that was any attempt to influence in any way anything besides what was simply testified to, I'll sustain the objection and ask the jurors to please disregard that, even though it was seemed to be a benign comment, but I understand the purpose of the objection. So,
Thank you, Your Honor.
in addition, with that testimony having concluded, I will again provide the jury with an instruction that's been previously provided and will also be provided in your closing instructions in relating to these acts and allegations alleged to have taken place in Arizona. That is evidence that has been introduced for the purpose of showing the defendant has possibly committed acts other than for which she is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character in this case, or that the defendant has a disposition to commit crimes. That evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So that's the instruction as it relates to the limiting nature of that evidence that was just entered into by the state. All right. I believe at this point the state intends to not call another witness until tomorrow. Is that correct?
Yes, Judge. The next witness is fairly lengthy, and understanding that we had to end early today for other matters, the state would request that we start that lengthy witness tomorrow morning.
All right. Thank you, counsel. We'll go ahead and have the jurors excused for the day then. We'll take a 15-minute recess or so, then we come back on the record for additional argument on an evidentiary matter in this case. So before you leave, let me just give you the daily admonishment. Please continue to abide by that. Don't discuss the case with anyone. Don't discuss it amongst yourselves. Please don't do anything to look the case up, or if you see it in the media, don't follow it at all. Don't do anything that would impair your ability to continue to render your fair and impartial service based only on evidence that's presented here in the courtroom. So we appreciate you adhering to that every day, the court and the parties both. With that in mind, you're excused for the day, and we'll see you tomorrow morning at 8:30.
All right, please.
All right, let me just briefly inquire, counsel, on the argument you want to make. Is that enough time to be prepared for that, 15 or 20 minutes before we take up argument?
Yes, Your Honor.
Okay. And were you able to provide a courtesy copy of that proposed exhibit to the court?
I was not yet. I'm sorry. I was in witness. I will forward it.
Okay. If you could please email a courtesy copy to my staff, please.
Yes, sir.
Thank you.
Thanks.
Okay, folks, we'll be back.
Thank you. Please be seated. Okay, we're back on the record on case CR 22-21-1624, State of Idaho versus Lori Noreen Vallow. We've excused the jurors for the day. The court received a proposed exhibit, which would be a demonstrative or summary exhibit being proposed by the state in conjunction with the testimony of an upcoming witness in order to determine the objection outside the presence of the jurors and without using their time to do this. We scheduled it for this afternoon, and so the court will hear argument on the exhibit today. I've made a quick review of it. I intend to take up argument on it and then make a ruling, most likely just as we get started in the morning, unless I think there's any kind of a ruling that would assist the parties that could be made this afternoon. So Mr. Archibald has raised, is going to raise an objection, I'm advised. I'd like first for the state to just indicate that in fact the exhibit intends to be offered and who the witness would be that would offer the exhibit and a description of the exhibit, and then I'll go to Mr. Archibald's objection.
Thank you, Your Honor. It's an exhibit from Douglas Hart. He was the former special agent who ran criminal investigations for several counties in southern Idaho and supervised the agents who do criminal investigations both out of Boise and the Pocatello offices. The agents in the Pocatello office reported to him. He, as the supervisor, had to sign off on every report through every federal officer through the FBI.
Just to clarify, he's an FBI agent?
He is an FBI agent, special agent.
Thank you.
And he retired in 2022 and is now the chief deputy for Canyon County. But he would be testifying as to his role, which has been ongoing in this investigation. And so to be clear, he, every FBI agent, every part of the FBI that had contact with this case reported to him. In addition, and so as a part of that supervisory role, every report, every analysis, every assignment was authorized by him or signed off on by him. And so he has reviewed literally and or signed off on every report done by any member of the FBI in this investigation. But more importantly, but in conjunction with that, he was also an active investigator on this case. Given the resources in the two offices for the FBI and given the resources for the departments, this what the court has heard numerous times, this was a joint investigation because you want me to keep going, Judge?
You may.
Okay. No one officer or department had the resources to track this over the 5 or 6 states by themselves. And so this partnership, he was an integral part of the partnership of these equal agencies. But his role was unique given his experience, his background, and his in-depth research into multiple things. But the state is ask him to testify as to the findings he did. It's specifically documented in this exhibit as a summary. It is about the iCloud accounts of Lori Vallow. Those accounts have already been admitted, I think without opposition from the defense. Those records in their business records certification has been referred to by numerous people in terms of specific isolated items. But he will testify as to a summary of those accounts. Mr. Wood, in anticipation of this argument, did a search, just trying to put it together in a PDF. And I think at last count, there were in one of the accounts alone, 23,000 pages of documents that is reflected in the iCloud in one of the accounts that go and are attributable to Lori Vallow. They were handled and returned jointly. There's over 100,000 points of data or text or records in this. And so the state is certainly not proposing to print them all off and hand them to the jury. And so in anticipation of testimony and in trying to find the cleanest way to present very substantial and important information, former Agent Hart, Chief Deputy Hart, put together a summary, and that summary is based on the original copies which have been available to the defense since 2021 and to per previous counsel before that. He is also included in the summary that he has the line and or area that they could immediately go to locate to determine accuracy. He cut and paste from the original documents into the summary so that there's no conversation about attribution. He also has in order to take a summary and not just regurgitate 100,000 sets of data, I don't think any of us want to spend the year here. He found common topics, common themes that helped him present his findings. That makes it easier to present the information contained in these documents in summary. His background in an investigation, in supervision, in behavioral analysis is outstanding. He has the qualifications to make such a summary. He has the qualifications to take such summary and put it in context of the overall investigation, both from his personal experience and from his training, vacuum, and position at the time. And so the state's exhibit really is a way to move as quickly through important evidence as we can without losing context. It is a fairly lengthy exhibit. However, much of it is because the font is large, and part of that turns to so that it's easier for people to read. So it's easier for jurors to read, the court to read. And so the length shouldn't be determinative, but it's really a summary of voluminous documents in the most cohesive, chronological way the state can, done by the person who did the work.
All right, thank you for the proffer and description of the exhibit and argument as well, Ms. Smith. Mr. Archibald or Mr. Thomas, I believe it's Mr. Archibald that'll argue.
Yes.
Mr. Archibald, what's the contention of the defense in terms of the proposed exhibit? First of all, you've had a chance to review it, correct?
Yes.
All right, and if you'll present any argument in opposition, I'll hear that.
Yes, I'm making a motion, Your Honor, to exclude not only the report, but also the witness, Special Agent Doug Hart. This report was emailed to us May 2nd at 5:49, so 10 minutes before 6 o'clock on Tuesday. And so this is a common practice of the state of Idaho, in this case, from the FBI, to get us all their reports and then hand us a summary the day before the testimony. And so these summaries, again, have been proffered as demonstrative summary of their testimony. So the issue I have with Agent Doug Hart is twofold. One, he has met with many of the witnesses in this case. He has prepped them. He has met with the prosecutor in preparing these witnesses for their testimony. I first heard about Doug Hart's extensive involvement in this case when a witness of the state called our defense team sometime this spring and was concerned that the FBI wanted to talk to this witness again. So I contacted the prosecutor. What are you guys doing? We're not doing anything. The FBI is setting up another witness prep meeting, as it was called. So these witness prep meetings were set up by this Agent Doug Hart to go over this witness testimony. A dozen or so witnesses, all who have testified here during the last 5 weeks. And so Doug Hart is extensively involved in this case, as the state has just informed the court. So when we found out he was interviewing all of the witnesses, we asked for a recording. So the cops are interviewing all the witnesses. We want the recording. Oh, the FBI doesn't record it, is what we were told. Well, how about a recording from the prosecutors? Nope, we didn't record it. How about a recording from the local cops? Nope, we didn't record it either. So we were, as a defense, in the dark about why they were contacting witnesses again, why they were prepping witnesses again, and not provided with any recording so that we could review them. So maybe this is standard practice for the FBI. Maybe this is what they do. But I don't think we do this in the Idaho courts. I think if anyone was talking to a potential witness, it would be their lead investigator, Detective Hermosillo. Detective Hermosillo has sat here the whole time. He's an authorized agent of the state, but Special Agent Doug Hart is not. He's not a designee of the state, but he's sitting in on all these witness interviews. And so now they want to put him on the stand to testify. So number one, that violates our exclusionary rule. He has done exactly what we don't want witnesses to do, and that is talk to all the other witnesses. Number two, this report that he's generated that we just received contains argument. It contains the state's theory of the case. It's not his investigation of these 100,000 points of data. as the court can now see in this 160-page report, it contains argument on every page. Page 3, these are dates and times told to him. Page 4, common themes. Now, common themes, that's an argument. That's not a summary. Lori and Chad's doctrine on page 6. That's an argument. That's not a summary. Page 7 through 10. Doctrine. That's an argument. That's not a summary. Pages 10 through 18. Obstacles to remove. That's an argument. That's not a summary. Justification for their conduct. Pages 18 through 57. That is an argument. That is not a summary. Manipulate. Pages 57 through 79. That is an argument. As we just heard a witness today say, oh, that was manipulation. Oh, isn't that convenient that the FBI agent who he met with a day or so ago has that in his report, the FBI agent, pages 79 plus. Manipulation is what FBI agent Doug Hart has on every page in his, not every page, but from page 79 on, he refers to manipulation, and that's argument. That is not a summary. Removing obstacles, that's an argument. That's not a summary. So what we have here essentially is the FBI saying, from all of our investigation, here, state of Idaho prosecutors, here is your closing argument. Here is how you sell this to the jury. Here is our evidence. Here is our argument. And we're going to disguise this as a summary so that the jury can read it. And it's not appropriate. The FBI is not in charge of this case. The federal prosecutors are not in charge of this case. This is a state case run by the state of Idaho prosecutors. And so this is the FBI's way of telling the locals that this is how you do a case. So this 160-page summary, so-called, it's just cherry picking. All of this data has not been admitted. There's not 100,000 pages that's been admitted. If it has been admitted, Your Honor, then they don't need to be summarized. So if this evidence has already been admitted, we don't need a summary. We don't need this witness. So I'm very concerned about this witness testifying, again, because he's talked to, I don't know how many, because I haven't been told that information, so I can only guess. But the lay witnesses he's talked to, all the FBI agents, the state of Idaho has just now said Doug Hart was in charge, so all the FBI agents who have testified have reported to Doug Hart. So he's now summarizing the case, and that's just inappropriate. So we'd ask that he be excluded, and then if the court's not willing to exclude him entirely, exclude his summary. Thank you.
All right. Any rebuttal argument, Ms. Smith?
Yes, especially since some additional issues were raised, Your Honor.
Yes.
To start with,
would you address first the timing of the defense receipt of the 160-page PowerPoint?
I think a lot of that had to do with
Are you confirming it was received 2 days ago?
The exhibit was sent on May 2nd. And part of it was that's when we got it for him. He has another job. It's an exhibit to ease and create his testimony. It has been on the exhibit list for a substantial period of time.
it's one thing to put it on a list, but nobody's been able to see it until 2 days ago, correct?
Understood.
Okay.
And understood. But no, that the timing on that is correct. I think there's another piece of it is when he submitted it to us, there were some things on there that we weren't sure had come in. I didn't want anything in there about Joe Ryan. And so part of that was if we're going to use an exhibit that is summary, we also have to make sure when we proffer it to the court or to opposing counsel, there isn't something that the court's previously excluded. Sure. And so there's a degree to which with summary exhibits to be offered to a jury, we have to walk a very fine line that we don't violate any of the court's previous rulings. And that's part of the reason he's towards the end of the case, because you certainly wouldn't offer a summary exhibit that has things in it you either A, can't get in, B, don't get in, or later are told don't go there. But absolutely, that's what it was. The second piece is, I do find it interesting. Had the state done preparation of its witnesses with just a prosecutor present, I guarantee you, and the court's already heard it, defense counsel would be in here saying disqualify those prosecutors because they talk to people alone. So at this point, the defense can't have their cake and eat it too. They got to pick. Discovery is ongoing. We had the officer or the agent who was involved in the interviews sit in on our conversations with our witnesses to make sure if the witness said something new, if they gave something different, that the person who had talked to them or worked with them could report that, turn it over to defense as quickly as it could, even if the discovery deadline had passed, because we recognized that deadline was for admissibility, did not mitigate our responsibility to disclosure. And so to say the person with the deepest knowledge should not be in the room to make sure that Brady or exculpatory information is a stretch. Prosecutors absolutely would commit malpractice if they put their witnesses on the stand without talking to them, preparing them, and making sure they followed the court's rules. We did that in this case. We're not going to put somebody up there we don't know what they have to say. And we made sure we had a witness present to ensure the commitment we made to you, which was discovery was ongoing, was committed. So it is a bit rich for the defense to say, hey, you're giving us too much discovery, and the person who gives us the discovery we want to exclude now because they did their job. So on the discovery issue, that is our obligation. He did what he was told. If the court wants, they can certainly question him about a cross-examination. The other piece is no one has discussed testimony with him that occurred in this courtroom, and he will tell you that. And so what he did in anticipation of testimony is different than what came out in. If it is different than what came into the courtroom, he can't speak to that. He is not going to comment on what somebody else said or did unless we have to lay a foundation for prior inconsistent statement or it's otherwise admissible. What his testimony will be about in this case is about the work he did on the iClouds and how it fits into the overall investigation. That was his job. He did this work. The other piece is these items were admitted under State's Exhibit, and forgive me, it just went out of my head. It's the iCloud summary. I want to say it's 104, but let me pull it up. The Apple Certified Business Records for Lori for Style, the Apple Certified Business Records for Lolly Time. It was Exhibit 29. It came in probably day 3 of the case. Multiple witnesses have referred to those documents. The original and the entire content, all 100,000 data sets plus the individual pages, which total over 24,000 pages of documents, have been available to the defense. We certainly could throw them on a disk and give them to the juror, but that would be really burdensome. So what former Special Agent Hart did was to be able to accurately convey his testimony, was create an exhibit to aid himself in explaining his findings, to the jury and to aid the jury in understanding the evidence they've been giving them. That's part and parcel of a summary exhibit under Idaho Rule 1006. The other piece of it is to just throw things up there without context does not make sense. Those are common themes and ideas he found. The fact that it could also be used in closing argument just shows the validity of the evidence and the investigative conclusion. Investigators follow leads. They follow the evidence where it gives them. That evidence gives them themes and ideas, and they present that to the state. This document is a direct example of what law enforcement does, and it summarizes in a usable way for this jury voluminous records that he has personal knowledge and information related to that. It is a way to take what is a vast amount of information and give it to this jury and to the court in a manageable setting. The discovery in this case is extensive for all the parties, and the court's seen that. We cannot ask this jury to sift through 100,000 records without some frame of reference, without some theme, and expect them to come up with a good result. And this solution is the best solution that the agent and the state could come up with.
All right. I've heard argument on the motion. I'm prepared to make a ruling at this time, having considered the argument. I will note I did briefly scroll through the proposed exhibit, and one thing I'm not entirely sure we got on the record is whether or not it's been previously marked or labeled with a number, so we can correspond in the record what I'm referring to and what you've been referring to. Is it a state's proposed exhibit number?
I apologize. It should be States 183. It's on the physical copies. I apologize. It's probably not put on there electronically. I simply forwarded it to counsel in the court without an exhibit sticker just to try to get it to people.
Okay. All right. So the proposed exhibit 183, I'll start off first with the defense contention that Agent Hart should be excluded for violation of the court's exclusionary order. That order is narrow in scope to what the rule prohibits, which is a witness listening to trial testimony. And while the agent may have interacted with other witnesses, I don't see any indication that the conduct would go directly to the court's exclusionary order unless he states on the stand that he's been talking to witnesses about their testimony or reviewing their testimony before he has testified in the case since trial started. Because he's not the state's designated agent that gets to sit through testimony. So I'm not, at this point, don't see any violation of the court's exclusionary order. That's something that the witness can address on the stand once he's placed under oath, and potentially in cross-examination if the defense believes he may have violated the order. So at this point, the record doesn't make clear that there has been any violation if he were discussing the case with witnesses before they testified. So the witness is not excluded. The next question then becomes, if Agent Hart testifies, does he get to use what's been proposed as Exhibit 183? That's a summary, or it's labeled or been argued to be a summary under Idaho Rule of Evidence 1006. That rule does allow a proponent to use a summary chart or calculation to prove the content of voluminous writings, recordings, or photographs that cannot be conveniently examined in court. The second part is the person offering it needs to make it available for examination before of the underlying information that goes into making the summary. I think the state's established that this information, while very voluminous, has previously been provided in discovery. I think there's been enough of a foundation laid that part 2 of the rule would be complied with where it was prior disclosed in discovery, and potentially the excerpts that are included in this proposed exhibit have been available to the defense. I am going to exclude that exhibit, though, for the following reasons. Number one, the size of it, the contents, the volume of the exhibit itself is concerning to me, that it was provided to the defense late in the trial 2 days ago. It's a 160-page exhibit. Not fair to have the defense need to be able to go back through what everybody concedes is a huge amount of information and determine whether or not the 160-page exhibit comports with the underlying information that was used to make the PowerPoint. The bigger issue I see also is I do agree with the defense that it's not just a summary of content. It's not here's an email, here's a text message, here's what it says. That's all allowable under Rule 1006. What the exhibit does is, when I look at it, it looks like a closing argument PowerPoint we're going to have at the end of a trial, where someone's tying all the evidence together, they're editorializing on the evidence and what it means, they're interpreting the evidence, they're pulling it together in such a way with some of those terms that Mr. Archibald indicated and that I saw in there as well, talking about what are the common themes. It refers many times to what it calls the affair that was taking place. I think it goes right into the provenance of the jurors to interpret the evidence and for them to make determinations about what the evidence means. The amount of what I think is argumentative type of language that is used to tie it all together, to me, it does strike me as like a opening first closing argument that would be played for the jurors before the prosecutor then makes a closing argument. So if it were an exhibit of admissible evidence that was being proposed in a closing, I wouldn't take any issue with it, but the way it's been prepared and presented, I think, goes outside of the scope of what the rule intends. The rule simply allows for summaries of the information, but not comment on the information, not interpretation of the information, not statements of argument that claim to tie the information to the theories of the state in the case. So it's an improper use of Rule 1006. So the exhibit as it is would not be admissible. With that in mind, I would indicate to the state, if the state submitted a follow-up exhibit, and I understand already with the timeliness issue, I still may or may not allow it, but if all of that argumentative language was removed and it was simply references for convenience of certain communications you think he should testify about, that is something that the court would consider admitting. So the proposed 183 will not be admitted, and I'll sustain the objection on those grounds. If the state wants to have the witness create something else, and I feel like there's adequate time for the defense to be able to review it, assuming it wouldn't come in at 160 pages again and is something they could meaningfully prepare for, knowing the information contained in there has already been disclosed since May 2nd. I may consider allowing a different exhibit that assists the witness, but this one will not be allowed. So that'll be the ruling on that.
Thank you. In anticipation of that, may I ask a couple questions we will be trying to do that, and I really want to try to avoid successive sort of suppressions, if I may. So the objections are to the common themes discussion that's in there and to the headers. And is there an objection, just so I'm clear, to the timeline that he puts in there, which is critical to his when he discusses why a particular text is referenced. So I'm sorry.
I don't think timelines are objectionable as long as they're not, labeled about what they mean relating to some theory of the case. Also, these are, there was a lot of information in that PowerPoint that was argumentative. So I think the state can sort that out with my comments on what I think is proper or not. I will further entertain any objection based on the timeliness, again, depending on what comes back. If it's a cut-down version that looks manageable, and I think the defense has had an adequate opportunity to review since they have received the underlying information and discovery previously, it may be admissible, but at this point, that's about as clear as I can make it for the state.
Understand. And so should the state request to not call him tomorrow, but instead to call him on Monday? Understanding we follow the court's rule, is that something the court would entertain?
Well, your order of witnesses is up to you, but I'm not intending to just take a day off to let you have your witness prepare an exhibit tomorrow. We're going to be starting trial again in the morning, so if you've got other witnesses that can fill time tomorrow, it's up to you to choose the order of witnesses.
Okay.
All right. Mr. Archibald, do you have any questions or comments on the court's ruling?
No, thank you.
Okay. Thanks, counsel. That'll conclude the issue for this afternoon.
That wraps up segment number 4 in our coverage today. The trial of Lori Vallow Daybell. Press subscribe wherever you download podcasts. So you don't miss any of our coverage, courtroom action, interviews, and discussions on the case. I'm Tony Bruschi. Stay with us.
This is continuous coverage
Continuous coverage.
in the trial of Lori Vallow Daybell from the Hidden Killers podcast.
Hidden Killers Podcast.